Now, the first thing I want to say about critical race theory is that the origins of critical race theory go back to the 1970s. It's not history. It's simply a framework that began with some scholars and professors in the 1970s in which all they were doing was examining the impact of systemic racism, institutional racism on our legal system. Now, over the next several decades, critical racism expanded to examine other institutions, employment, the environment, education. But most importantly, critical race theory is not being taught here in Pinellas County. In fact, to my knowledge, it's not being taught anywhere in the United States. And it's important that we all be on the same page about that. I earned my master's degree in African American history. I teach the subject at Dunedin High School. I only just learned about critical race theory for the first time in late 2020. We're too busy as professional educators, as you know, just getting through all the material. We're not here to indoctrinate students. We're not here to teach our students to hate America. And so what I'm asking you all to do is consider a joint statement from Dr. Grego and members of the board, making it clear that we don't teach critical race theory. What we do is we teach our students to examine deeply the history of this country because we're preparing citizens to be functional, wonderful citizens in a democracy. That's what we do. And so I hope you all will consider that. And as we come out of the pandemic, it's really essential that we remember that we ought to be honoring teachers and thanking them for everything we've done in the pandemic, not labeling and demonizing our profession. So I just want to say thank you so much. I'm really looking forward to next year, and I hope we'll continue in our partnership in dealing with issues, of course, like restorative practice and equity and culturally relevant teaching. You know, the real foundations of everything we do. So thank you all so much, and you all be well.
Welcome.
Thank you. I appreciate the opportunity to speak. My name is Rob Sabursky. I'm a resident of Pinellas County living in Safety Harbor. And I'm here to support Brant Robinson. What he said was excellent. Everything Brant said should be taken to heart. But the reason I came was to present a potential ramification to this new law. And with that, I'd like you to take a moment, in keeping what Brant said, keeping it in mind, I'd like you to think about the time before the school year begins and this new law is applied. I'd like you to envision a Florida legislator seeking to ingratiate himself or herself with the base of a certain political party and perhaps a certain lobbyist, and in doing so, sponsoring a bill that results in enacting a penalty provision for violations of this law. Yes, a penalty provision. For any member of the school system, the provision provides for, number one, that the governor can remove the teacher or school system official without a hearing. Number two, that the teacher can be immediately fined up to $5,000. And number three, that the teacher can be exposed to an unlimited number of lawsuits up to $100,000 in attorney fees. Furthermore, the accused school system official cannot call upon a county attorney for counsel, and that the fines must be paid personally by the official. Chilling, isn't it? You may be thinking at this point, and I don't blame you, that what I'm saying is outrageous, that it can't happen. But with that, I'd like you to think about what happened with Florida's firearms preemption statute enacted in 1987 and the penalty provision enacted in the year 2011. With what occurred at Sandy Hook, at Stoneman High School in Parkland, I suspect that each of you are familiar with these penalty provisions because they can affect you. They can affect you if you feel there's a need to enact rules or regulations aimed at protecting students, teachers, and administrative staff from gun violence. I assume that you're aware that a lawsuit was filed challenging these penalty provisions. You may be aware of the fact that Leon County Circuit Court Judge Charles Dotson ruled these penalties unconstitutional in what I consider a well-reasoned opinion. But an appeal was filed by Governor DeSantis, Attorney General Moody, and FDLE Commissioner Swearinger, with Florida's first District Court of Appeal, and they appealed the second and third parts of the penalty provision, and that the first District Court of Appeals ruled in favor of the appellants. We're waiting now to see if the first District Court of Appeals will certify the matters in this case. Another sentence, going to continue or finish? Okay. We're waiting to see what's going to happen if it's going to be certified as a matter of public importance and allow the Florida Supreme Court to review it. But I just want to throw that up as something that you may want to consider. This is a law with ramifications, potential ramifications. Thank you.
Our next